We'll go to problem number 36. That is A, B, and C are sureties to D for the sum of 3000 rupees lent to E. E makes default in payment. What are the liabilities of A, B, and C of each? So the very problem relates to the provisions of section 146, and as it provides co-sureties liable to contribute equally where two or more persons are co-sureties for the same debt or duty, either jointly or severally, and whether under the same or different contracts, and whether with or without the knowledge of each other, the co-sureties in the absence of any contract to the contrary are liable between themselves to pay each an equal share of the whole debt or of that part of its which remain unpaid by the principal debtor. Here the whole debt amounts are 30,000. So A, B, and C are liable to pay each an equal share of the whole debt. A, B, and C are therefore liable as between themselves to pay Rs 1000 each. And the next problem is the problem number 37. A fraudulently sent forged money orders to B, which were to be accepted on A's behalf. The post office duly made payments to B, who was innocent of the fraud. A thereafter collected the money from B and disappeared and convicted. Government filed a suit against B to recover the money. Will government succeed? The facts of this problem are as under section 72 of the Contract Act. So as it provides a person to whom the money has been paid or anything delivered by mistake or under coercion must repay or return it. Every case relating to this very section depends upon its own facts. So here B was not a party to fraud. Moreover, he was not unjustifiably enriched. Looking to these facts, it is clear that the government will not succeed in a suit against B to recover the money. And the next problem is the problem number 38. A directs B to sell goods for him and agrees to pay B for V 5% commission on the price fetched by the goods. A authorized before, afterwards by letter revokes B's authority before receiving it, sells the good for 100 rupees. Is the sale binding on A, and B is entitled to any commission? So the very fact of this problem is as per the provisions of section 208 of the Contract Act, the very termination of authority of an agent does not show fair as regards the agent take effect before it becomes known to him or so far as regards the third person before it becomes known to them. So here B sells the goods before termination of his authority becomes known to him. So the sale is therefore binding on A, and B is entitled to 5% of 100 rupees as his commission. And our next problem is that problem number 39. D agrees to serve B, a physician and surgeon at Zanzibar, as an assistant for 3 years. The letter which stated the terms which P offered and D accepted contained the words the ordinary clause against the practicing must be drawn up. No formal agreement was drawn up, and at the end of a year, they ceased to act as P's assistant and began to practice in Zanzibar. So, advise P. So, as per the very problem, it is similar to the leading case, that is Shell's Worth versus McDonald. So, according to section 27, every agreement by which one is retained for exercising a lawful profession, trade, or business of any kind is to that extent void, but there is one important exception to this section, is that one who sells the goodwill of a business may agree with the buyer to refrain from carrying on a similar business within the specified local limits as long as the buyer or any person deriving title to the goodwill from him carries a like business therein, provided that such limits appear to the court reasonable regard being had to the nature of the business. But the agreement of the class in which Charlesworth versus McDonald do not seem to be falling within section 27. All agreements for personal service for a fixed period would be void. An agreement to serve exclusively for a week, a day, or even for an hour necessarily prevents the person so agreeing from exercising his calling during that period for any one else than the person with whom he so agrees. It can hardly be contended as such an agreement is void. He is therefore entitled to an injunction restraining D from practicing in Zanzibar on his own account during the very period of the agreement. And now we'll go to the next problem, and that is the problem number 40, where A agrees with B to discover a treasure by magic whether the agreement is valid. So, an agreement to do an act impossible in itself is void as per the very provisions of Section 56, Clause 1 of the Contract Act. To discover a treasure by magic is an act impossible in itself. So the agreement between A and B is therefore void.